Hey everyone, today we are talking about a very important topic, the divorce process in Singapore. Getting a divorce can be overwhelming. So in this video, I will guide you step by step through the entire process. Whether you are contemplating divorce or just want to learn more about the legal procedures, this video will break down the key stages involved. In Singapore, divorce is governed by the Women's Charter, and to file for divorce, you must meet certain eligibility requirements. For example, you must have been married for at least 3 years, unless you can prove exceptional hardship or other circumstances. You must also be a Singapore citizen or a permanent resident, or have lived in Singapore for at least 3 years before filing. If you meet these requirements, you can move on to the divorce process itself, which consists of several key stages. It is important to note that before you file for divorce, you have to attend a mandatory parenting program if you have a child. So the first step is filing for divorce. This begins when one party, known as the plaintiff, files a writ for divorce and a statement of claim. The statement of claim outlines the facts of the case, such as the reason for the divorce. In Singapore, the grounds for divorce are based on the irretrievable breakdown of the marriage, which must be proven by one of 5 facts: adultery, unreasonable behavior, desertion, separation for at least 3 years, or separation for at least 4 years if the other party does not consent. Along with these documents, you will also need to submit a statement of particulars and a proposed parenting plan if children are involved. Step 2 is the service of divorce papers. The writ for divorce and other documents must be served on the defendant, that means your spouse. This is done either through a process server or by registered post. If your spouse is cooperative, they may sign an acknowledgement of service. However, if your spouse avoids service or cannot be located, there are special methods such as substituted service, where the court allows alternative methods such as serving through social media or newspapers. Step 3 involves your spouse's response. The defendant has 8 days to file a memorandum of appearance indicating whether they intend to contest the divorce. If the divorce is uncontested, the process is much smoother. The defendant may also file a defense and counterclaim if they dispute any aspects such as the grounds for divorce, division of assets, or child custody arrangements. Step 4 is the interim judgment. If the divorce is uncontested, the court can grant an interim judgment relatively quickly. This is the first official step in dissolving the marriage. The interim judgment marks the end of the first stage of the divorce process. However, it's not the final stage. The court will still need to deal with ancillary matters, such as the division of matrimonial assets, child custody, and maintenance payments before issuing the final judgment. Step 5 involves addressing ancillary issues. This is where the court decides on issues such as the division of matrimonial assets, custody, care and control of children, and spousal and child maintenance. Both parties will need to file affidavits of assets and means to declare their financial status. This process may require mediation sessions if there are disagreements, and mediation is encouraged to settle disputes without going to trial. Finally, step 6 is obtaining the final judgment. Once all ancillary matters are resolved, either through agreement or court decision, the interim judgment can be made final. You must wait 3 months after the interim judgment for this to happen. Once the final judgment is issued, the divorce is officially complete, and both parties are legally free to remarry if they choose. Thank you for watching. If you found this video helpful, don't forget to like, share, and subscribe.